categorizations. There's chest pain that can occur if you are going to have a heart attack, medical terms called myocardial infarction. That, when you say you have chest pain in that category, we look at the possibilities of that being real. That's what we call the risk factors. And here's a man at his age.
Madam, my lady, with a very kind permission. With a very kind permission. I have listened to where the evidence, my lord, is headed. And in my very humble view, we appear to be expanding the scope of the petition and the affidavit that is before your lordship. But it is important that we stick to what is in the affidavit for purposes of, that is why we are here today. If we attempt to then expand it beyond what we agree, then we'll be prejudiced. We'll have to find further affidavits, etc., etc., to be able to respond to the questions that are being raised. We must, I submit, stick to that.
You have filed an affidavit in this person?
We have, on behalf of the Senate.
My Lord,
yes.
If I may respond, I would refer the court to paragraph 5 of the affidavit. Basically, the questions are formulated based on what the witness deponed to. Unless they specifically state exactly what is new, my Lord, we request that you do allow the witness to proceed with his testimony.
Laying a basis does not presume introducing new issues by way of evidence. It doesn't mean you then introduce new technical issues that we need to deal with. We would have to respond.
I think the way forward is, Ms. Waigwa, you will refer the witness to particular paragraphs of the affidavit.
You do have the affidavit with you?
I do have it, Your Honor, in front of me.
Okay. Please clarify what you meant under paragraph 5 of your affidavit.
Your Honor, paragraph 5 asks, based on my professional expertise, what do these symptoms mean? That, your Lordship is what I understood. My answer to that is that, based on my experience, those type of symptoms, depending on the probability of disease, which depends on your risk factors, would imply that you could be having a heart attack. That is my simple answer.
And based on paragraph 6 of your affidavit, what role or steps did you take with respect to the first petitioner having been presented before you?
Your Honor, if a man of that age and risk factors presents, there are standard protocols that we follow in medicine to evaluate that person. In this particular person, I must admit, there was additional risk factors of stress. And stress has got its own problems of affecting the heart in a condition that we call the Takotsubo syndrome.
I refer you to paragraph 7 of your affidavit. Please clarify what you meant in that affidavit on paragraph 7.
Again, Your Honor, in medical practice, and it is standard that can be confirmed from all parts of the globe, if somebody presents with chest pain in hospital and has necessary risk factors, you are then hospitalized for evaluation to see the extent and the dangers at which this poses.
What examinations did you conduct?
The examinations, again, Your Honor, are standard. Apart from the physical examination, taking a proper history of the circumstances, then you proceed with specific tests, which includes what we call a tracing of the heartbeat for purpose of this court, called an ECG, an ultrasound of the heart for this purpose of layman's terms, an image of the heart, and blood tests to check for any heart muscle damage, which again, Your Honor, is all standard.
Madam, very kindly, as my Lord did direct, could we be pointed to specific parts of both the affidavit and the attachments that then align with what the good doctor said? My concern is what, Madam, by seeking clarification, we are then proceeding or extending beyond what is contained in this document. It then leaves us in a very precarious position.
I think that the doctor is here to give us expert evidence, and we must give him the room to give that evidence.
Yes. Can we clarify, my Lord, beyond that contained in the affidavit?
We know this.
Yes. My Lord, if I may assist the court.
Yes.
The issue being raised is we have a written affidavit, which is sworn testimony. Ordinarily, that would be the evidence in chief. The second issue is that it is right that where a thing has been reduced to a document, in this case, the affidavit and the annexures thereto, you cannot, under the guise of examination in chief, purport to add to subtract from, to contradict, or vary. Even if this witness were to spend 2 days here, it's just a waste of your time. Section 99 to 101 of the Evidence Act says that evidence is inadmissible.
I think, for me to this, make a very brief reply. The rule of objections, as I know them, is that you object to something, objection irrelevant, objection something. There's no specific objection. Being told that the objections, without a proper basis, we kindly request you to order that the examination in chief proceeds and concludes very shortly. Then my learned friends would have their time to impeach and to do anything lawful with the witness on the stand. Thank you, my Lord.
Ms. Waiwa, you will proceed with the latitude that those paragraphs in the affidavit gives you. And I think we must understand that we have an expert witness. There's a reason why we call him an expert. He has come to tell us something we may not know. Therefore, within that latitude, please proceed.
Thank you, my Lord. So, what you are referring to was in paragraph 6 of the affidavit?
Your Honor, exactly. That's the point. And the things I've mentioned are in that affidavit. The ECG, for the Swadasad electrocardiogram, the echo, and the blood tests. I've not gone outside that context.
Thank you. Please refer to paragraph 4 of your affidavit and annexure marked DKG 3. Annexure marked DKG 3.